Karen Reed's saga continues with a new defamation lawsuit. May it please the audience, I'm Rich Schoenstein. This is So Sue Me. I was not expecting to come back on this week, but I hold in my hands a 50-page complaint filed by Jen McCabe, Brian Albert, Colin Albert, and Brian Higgins against Karen Reed and Aidan Kearney, aka Turtleboy. And I thought I would give you some initial reactions to the complaint, the causes of action, and the now civil litigation going forward. This is not the first civil litigation in the case. We already have a wrongful death lawsuit. We have some other claims out there. But this is litigation I thought might be filed, but wondered if it would actually come, and now it is here. So here are your four plaintiffs: Jennifer McCabe, Brian Albert, Colin Albert, and Brian Higgins. These are all people who were supposedly inside the house at some point the evening John O'Keefe died and was later found buried in the snow outside of the house the next morning. If you followed the Karen Reed case, you know who these people are and you know how they're involved. Here are your defendants: Karen Reed, who was acquitted last year in a murder trial, her second trial, but she was acquitted, and Aidan Kearney, the blogger, journalist, whatever you want to call him, who goes by the name Turtleboy. And here's the lawsuit filed in the Commonwealth of Massachusetts Superior Court Department, 50 pages long. I'm not going to go through it paragraph by paragraph, allegation by allegation. You know by now I don't do that kind of thing. I will tell you what the causes of action are, and I will tell you what I think of it. Notably, let's start with this. Notably, it is filed by local Massachusetts counsel for the plaintiffs, but they are joined by Christopher Matai of the firm Koskoff, and Biter in Bridgeport, Connecticut. It's possible you recognize that name from the Alex Jones defamation litigation, because that's the attorney who spearheaded a $1.5 billion judgment against Alex Jones for what he had to say about the Sandy Hook school shooting and massacre. And if you followed that litigation, it was really well litigated on behalf of those plaintiffs and came out with a great result. Now, there's one key difference in these two cases, which is the plaintiffs in that case were completely innocent victims. They hadn't been accused of anything. They were family members of children who had been murdered at a school by a gunman. And so they were only sympathetic plaintiffs. There was no issue. And here, there are those who think that the defendants at issue here had some involvement themselves in the murder of John O'Keefe. I'm not going to resolve that issue, certainly not in this discussion. I've never really gone there to resolve it. There was a trial against Karen Reed, and in the first trial, the defense spent a lot of time pointing to what they said was a murder inside the house and a cover-up by the people who were involved in the house, some of whom were law enforcement and other law enforcement outside the house. That trial resulted in a hung jury. The second trial, the defense focused much more on reasonable doubt, which I thought was a much better strategy and got a much better result. It got a full acquittal because the Commonwealth of Massachusetts could not prove beyond a reasonable doubt that Karen Reed had killed John O'Keefe. There are those who say that they couldn't even prove beyond a reasonable doubt that John O'Keefe had been hit by a vehicle, much less killed on account of being hit by a vehicle, and therefore Karen Reed couldn't be convicted. But there are other people who say that a big problem in the trial was all the media and circus atmosphere surrounding it, and the fact that the jury pool had been tainted by some of the stuff that's an issue in this new defamation lawsuit. So basically, I'm going to really cut this case down to its key components. This case alleges that Kearney worked hand in hand with Karen Reed, that Karen Reed fed him information which he posted on the internet to accuse the four plaintiffs of having been involved in the death of John O'Keefe. The complaint alleges that Reed and Kearney knew that was false, knew that they didn't have anything to do with it, and did it anyway. The complaint alleges that Karen Reed did it so she would get an not guilty verdict at trial. She did it in order to affect the jury pool and as part of her defense. The complaint alleges that Kearney did it for money, that he did it in order to build his online brand, his subscribers, his contributors, and that he made money. The complaint says at one point he was making $45,000 to $50,000 a month posting information relating to the Karen Reed prosecution and spreading what the complaint says were lies about the culpability of these four plaintiffs. So the complaint says, and then the complaint goes through a lot of statements that were made publicly, especially by Kearney on his program on YouTube or otherwise on social media, where he accused the plaintiffs in this lawsuit of having murdered John O'Keefe. And so it puts a lot of those into the complaint to point to specific allegations that he made. Here's an example here of what I'm talking about. The complaint quotes a program that Kearney hosted in September of 2023 and quotes him as saying to his online audience, "What I'm saying right now is I'm not saying this as a matter of opinion. I'm saying this as a matter of fact that Jen McCabe participated in killing and planning to kill and cover up the murder of John O'Keefe. I am saying that. That is not my opinion. That is a fact." And that kind of statement, the idea that it was presented as fact and not just opinion, is going to be important in this defamation lawsuit for reasons I will discuss. And there are other allegations throughout this complaint about similar comments that were put out there by Kearney as expressions of fact as opposed to expressions of opinion. So the complaint covers the entire factual background relevant here from January 29th, 2022 death of John O'Keefe, which the complaint alleges was caused by Karen Reed driving drunk and backing into him with her Lexus SUV, through Kearney's involvement, his alleged coordination with Reed through an intermediary and through her counsel, including some in-person meetings with her and her counsel. They allege that they were utilizing the Signal app to communicate back and forth. Secretly, they allege that Kearney was being funneled information from the lawsuit that was filed confidentially so he could put it out publicly. The complaint goes through the two trials of Karen Reed and the fact that they were sort of a circus atmosphere, one leading to a hung jury in a mistrial, and the second trial leading to a not guilty. They allege here that Kearney admitted when the jurors came in, two of them smiled at him. He points to putting out a picture of him and Reed mocking Colin and Brian Albert. And then there's a section on the impact of the alleged conspiracy, which basically alleges that the four plaintiffs have been continuously harassed and intimidated, and their lives have been made very difficult by the public allegations that they were somehow involved in the murder. So we have a number of causes of action. There's a defamation and defamation per se claim against Reed, defamation and defamation per se against Kearney, aiding and abetting defamation against Reed, meaning she aided and abetted Kearney's defamation, and then aiding and abetting against Kearney, meaning he aided and abetted Reed's defamation. Intentional infliction of emotional distress, one count against each of them. Aiding and abetting intentional infliction of emotional distress, one count against each of them. Negligent infliction of emotional distress, one count against each of them. Aiding and abetting negligent infliction of emotional distress. civil conspiracy, which is kind of a throwaway claim you get in a lot of these cases, and then a somewhat more interesting claim against Kearney for violation of the Massachusetts Unfair Trade Practices Act. That is sort of like a false advertising claim that he was soliciting monies, that he used the likenesses and false informations about the plaintiff in order to profit on his online endeavors. And for all of that, at the end, the request for relief is an award of compensatory damages, an award of punitive damages, reasonable attorney's fees, and any other legal, equitable, or declaratory relief. It's a thorough and well-written complaint. I like it. It strikes a good balance between giving enough information to sustain a claim, but not being too much. I mean, you could have written this complaint, it could have been 500 pages because there were so many posts by Kearney. There's so much out there that you could have really overdone it, but I think an effort was made to have it be somewhat concise, but to still have enough information that it would set forth a sustainable cause of action. I don't really see any chance of getting the complaint dismissed. I think it does set forth causes of action that are viable, and so I think the case would go forward into discovery. Now, let me give you a few thoughts on it. Well, let me show you this, actually. I'm going to focus on defamation. I know there are other causes of action, but at its core, this is a defamation lawsuit. Here are your elements of a defamation claim: a false statement of fact, publication to a third party, fault amounting to negligence or higher, and damage and harm to reputation. So some of these are pretty easy. Publication to a third party, I mean, definitely Kearney's statements were broadcast purposefully on YouTube, on X, on other social media platforms, on his publication. So I don't think there's any issue about publication. I don't think there's any issue that there were damages. I think there's obviously some damage to these four. They've been maligned, they've been attacked, they've had to essentially go into hiding. I don't think there's any question. There may be a question as to the amount of damage. I don't think there's any question. So the issues in this case are really going to be, were there false statements of fact, and is their fault amounting to negligence or higher? Obviously, the greatest defense to a defamation claim is truth. And if you can establish that the comments at issue were true, there's no defamation claim. So if the four plaintiffs, Brian Albert, Colin Albert, Brian Higgins, and Jennifer McCabe, participated in the murder of John O'Keefe, they don't have a defamation claim. And one would presume that would be the primary defense of Karen Reed and Aidan Kearney, because they've been saying for years that that's the truth, that that would happen. Whether or not they can prove that remains to be seen. It's a different burden of proof. The fact that she was found innocent in a criminal trial is of no bearing. That doesn't affect a civil case because the civil burden of proof is less. You don't need proof beyond a reasonable doubt. You only need a preponderance of evidence. The jury is going to be told, if you think 50.00001% that these plaintiffs were innocent, then they were innocent. If you think 50.00001% that they were involved in the murder, then that's what you have to find. It's just on the cusp of 50-50 in a civil trial. And so the result of the criminal trial doesn't matter. This is going to be a new playing field, an even playing field. Also, you're going to get a lot more evidence in a civil trial than you can get in a criminal trial. There's much less fear about being unnecessarily prejudicial in a civil trial, so the amount of evidence that comes in is going to be greater. So whether or not these statements were false is going to be hotly contested in this case. Were they statements of fact as opposed to statements of opinion? That's why the complaint points to Kearney specifically saying these are not opinions, these are facts. He was not purporting to be a commentator commenting on the evidence. He was purporting to be reporting fact. It's one thing to say, I think based on the evidence I saw, that Karen Reed probably backed into her boyfriend, John O'Keefe, and left him to die in front of the house. It's a different thing to say, I know as a matter of fact and can tell you conclusively that she did it. Those are different. Opinion is generally protected. Statements of fact are not so protected if they violate the defamation standards. Fault is also an issue, right? And this is an issue. This is the one issue where I think, well, so you might say, well, doesn't Kearney have a right, free press, free speech? He's a journalist, or at least he's a blogger, whatever you want to classify him at. Doesn't he have a right to speak? He does as to opinion, but not necessarily as to fact. And that distinction is going to make an important difference in this trial. Generally speaking, I think this case looks slightly stronger against Kearney than it does against Karen Read. And here's why. Karen Read was a defendant in an ongoing murder prosecution, and a lot of her conduct is protected, is privileged because she's involved in a criminal case. She's allowed to say things in the criminal case even if they're potentially defamatory. You're allowed, if you're a criminal defendant, to accuse somebody else of committing the crime. That doesn't subject you to defamation. What you do in a courtroom, what you do in a legal pleading, what you say to a jury is generally protected. The difference is when you go out on the street and say it, or you go on TV and say it. There are allegations in this complaint that after the trial, she went on a podcast appearance and accused these plaintiffs of having been involved in the murder of O'Keefe. That may not be protected, but what she did at trial would be protected. Now, the complaint also argues that basically this was a scheme where Read and her attorneys funneled information to Kearney, knowing that he would disseminate it. And that's why there are those aiding and abetting allegations in there. And you might find that those are defamatory statements, even though they didn't make them directly. But it's a little bit tougher, right? The complaint names time after time after time that Kearney directly accused the plaintiffs, or at least some of them, of being murderers, and they don't have that kind of allegation for the most part for Read because she wasn't saying those things publicly during her trial, and what she did at trial can't constitute defamation. I hope that makes sense. Now, there's one part of this case that is stronger against Read, and that's fault, because I showed you the elements. The third element is fault amounting to negligence or higher. So if Read actually killed O'Keefe, then her accusing other people of doing it was obviously negligence or higher. It was intentional. She knew they were innocent because she was guilty. Kearney, on the other hand, wouldn't necessarily know for sure one way or another. And he might have been disseminating information based on what he thought the evidence said, and will argue that even if it turned out that that was untrue, even if it turned out that the information he was putting out there wasn't accurate, he had good reason to believe in its accuracy. He had hundreds of reasons to believe in this accuracy. He was concerned about the role of Boston law enforcement. He was concerned about the investigation itself. He was concerned about bias that was apparent against Karen Read in the course of the investigation, and the connection between the investigators and the people in the house. And all of that led him to make these statements. And he was concerned that an innocent woman was getting railroaded. He could try to point to all of that and say, even if this stuff wasn't true, it's not my fault. I wasn't negligent in putting it out there because it was perfectly reasonable to put it out. In fact, many people to this day believe it's true, although that's a little bit of a circular argument when you think about it. So overall, I think the defamation case is stronger against Kearney. Also, he's got a profit motive alleged for putting this stuff out there. He's trying to build a platform and make money off of it. And Karen Read is just trying to stay out of jail. So in a defamation context, his motive is less supportable than hers. She's trying to fight a legal case. He's just making a profit. There's a lot there in this case. I mean, I'm only scratching the surface just to give you some initial reactions. In this kind of case, assuming it goes forward, assuming it gets past a motion to dismiss, it will enter discovery. And that will be extensive, digging into whatever communications Reed and Kearney had with each other. Again, civil litigation, unlike criminal matters, Karen Reed has to testify. There will be a deposition of her if this lawsuit goes forward. There will also be depositions of Jen McCabe and the Alberts and Brian Higgins. There will be depositions of those. There will be deposition of Aidan Kearney after they hand over all of their communications and relevant evidence. And that will be fascinating to watch. Following that kind of discovery, there would be potentially summary judgment motions with both sides arguing that the case should be either resolved in favor of the plaintiffs or dismissed, and assuming that there are issues of fact, credibility disputes, and that kind of thing, the case could go to trial, as the Alex Jones cases went to trial. Now, you may remember in the Alex Jones cases, he refused to provide a lot of discovery that was required by the court and ended up forfeiting essentially on liability. And ultimately, the trial against Alex Jones had more to do with damages than liability and amounted in those massive verdicts in favor of the plaintiffs. Very well done by counsel there. Presumably, a trial in this case, liability would be hotly contested. Liability would be hotly contested. Damages will be hotly contested. Will it go forward to trial? I mean, most civil cases don't. I've said time and time again, most civil cases are resolved on the papers or settled. Are these parties going to reach a settlement? I don't know. Fascinating development in the Karen Reed case. I'm going to stay on top of it because I'm interested. And I'll be back to report more if and when it happens. Thank you for watching. Don't forget, like, subscribe, all that jazz. We'll see you soon. For now, we are adjourned.